This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions all about workers' compensation. If you got hurt on the job, probably your company has got a certain kind of insurance that would help pay some wages to you while you recover. But you have to do it the right way. You have to report it the right way. Your employer has to report it the right way and handle it the right way. If something happens, like if your employer is asking you to just wait and see if you get better, that's a bad sign. There are certain steps you have to take. If they're acting like it's all your fault, if they fire you because you got hurt on the job, tonight's the night to call in and ask your questions. The 31 Law Call number 536-0077. You can also email a legal question. You can email it any day of the week on any legal topic, and when we get to a show that's on point, we'll pull some out. We've got some of your workers' compensation emails tonight. Getting us started tonight, we've got William Meservey and Bobby Marsh from Timberlake, League and Brooks here to answer questions. Glad to have y'all here tonight.
Glad to be here.
We've also got some video to start off. So not related to workers' comp yet, but this video, we like to pull something off of YouTube. You make the law call. So this young lady's pumping gas. She gets back in the car for a minute, comes back out. We're talking about static electricity. You know, maybe sometimes you scuff your feet on the carpet and get a little shock. Sometimes it can be worse. I think she rubs her sweater, and that may be what caused it. So she's okay. Everything turns out okay. But if it looks like she got off pretty easy. You guys do all kinds of personal injury cases. If something like that happened, is that like an act of nature if it had been a really bad incident?
So it can be what is called an act of God or an act of nature, and that is actually a defense to a claim. So if you were to allege a claim here and say, look, they didn't have proper safety mechanisms in place to prevent such an action,
yeah,
they can say, well, this is an act of God, right? Or this is an act of nature. But at the same time, a company has to take reasonable steps to prevent injury for what is a hazard that they know about or should know about. Right? And so this is obviously not the first person to encounter a fire or a static electricity discharge at a gas pump. And I do believe there were some safety precautions in place that maybe we can't see because, you know, the gas automatically shuts off when it detects certain things, or there may be other things, but there was no big, huge explosion
at the end,
right? Absolutely. And so, you know, we don't know exactly what safety precautions they had in place, but they seemed to work, whatever they were.
Thank goodness she's okay. Makes me, I want to be more careful pumping gas.
Right?
Yeah, I'm not wearing any sweaters to the gas pump.
That's right.
So tonight we're taking your calls and questions about workers' compensation. And workers' comp is a kind of insurance. What's the basic idea for workers' comp? Why do we even have this kind of insurance with employers?
Well, yeah, so workers' comp is a statutory scheme. Okay, so it is codified law through the state legislature. And what it says is that if you're injured on the job, you're entitled to certain benefits. But it goes sort of back in time, okay? So you've got to go back all the way to the Industrial Revolution when you had folks coming off of farms to work in factories. There was no OSHA, you know, and you had people getting hurt, maimed, and killed left and right.
Yeah.
And eventually labor and management came together because those injured claimants, if they could prove the company was at fault, which the vast majority could not. You know, this was well before security cameras and any sort of thing like that, right? And so if they could prove the company was at fault, they'd get these big settlements to include pain and suffering, mental anguish, these different things. But if they couldn't prove it was the company's fault, then their families would starve. And so labor and management came together and developed what's known as the workers' compensation system. And ours is based off Minnesota's for whatever reason. But the short of it is that if you're injured on the job, you no longer have to prove fault. As long as you weren't injured through horseplay or willful misconduct or a violation of a safety rule or something along those lines, you're going to be entitled to workers' compensation benefits. And this is assuming your company has more than 5 employees. And so if that's the case, then that company is going to have a policy of insurance with an insurance company that's going to provide workers' compensation benefits to an injured party. And, you know, those benefits are mainly medical treatment for the rest of your life as it relates to that particular injury, what's called temporary total disability, and that's simply 2/3 of your average weekly wage, and that's non-taxable, so it should be similar to your take-home pay.
Okay, so it's not as low as I was thinking. If it's not taxable, that's pretty good.
It's not taxable, so it should be somewhat similar to your take-home pay. And then lastly, you're entitled to some sum of money for either permanent partial impairment or permanent total disability. And so that would be if the injury left you maimed or left you with some physical impairment, like broke my shoulder and now my arm only goes up this high, right?
Okay.
So there are different things that could include, but that's sort of the value driver for what your claim may be worth.
Okay. What if your employer doesn't handle things correctly? I mean, can they fire you? Can they fire you for getting hurt on the job?
So I think it's, more so the way to look at it is, can they fire you for a workers' compensation claim? And the answer to that legally is no. You could absolutely not be fired for filing a workers' compensation claim on its own. However, we are an at-will employment state, so you could be fired for any reason or no reason at all, with a few exceptions, if you're in a protected class, for instance. The important thing to know, though, is that if you were fired, and you believe it was based on your workers' compensation claim alone, you may have a retaliatory discharge case. Now, retaliatory discharge, the main thing there is being able to prove that you were fired solely because of that workers' compensation claim. And that can be a little bit difficult when they can find other reasons, such as missing work in the past or poor performance, for instance. Those things could ruin that retaliatory discharge claim. So
if you make that case, a retaliatory discharge, and you win, you've proved your case, what's the value of even doing that?
Well, you have to show your damages. So, if you looked for a job for 4 months and were unable to find employment, you may have 4 months of lost wages would be your damages. There can be damage to your reputation. There can be various damages, but generally they're going to be limited or somewhat related to your loss of income during the time that you were seeking new employment, or if you found a job quickly thereafter, but it's $3 less an hour, then you may have some, damages related to the difference in pay.
Okay, walk us through the right steps to take if you're hurt on the job. Are there things that you need to do in a certain span of time? What do you need to do to be sure that you lock in your ability to make that claim?
The most important thing is that the Workers' Compensation Act in Alabama says you have 5 days in which to provide written notice to your employer that you were injured on the job.
Okay.
Now, that's been interpreted by the Alabama Supreme Court to include oral notice as well. And then there is constructive notice, which would be, look, my supervisor was out there when the ambulance showed up to haul me off. So, well, no, I did not, explicitly tell them that I was injured on the job.
But he knew.
They knew because the ambulance was there to pick me up, right? So you can prove notice through a variety of ways, but it's very, very important that you stay within that 5-day window and that you tell your supervisor or go through the proper channel at your particular place of employment to inform them that, hey, yesterday while I was on shift, my back, went out. I thought I'd be fine, but this morning it's worse than it was yesterday, and I need you to send me to the doctor.
Okay. We've got callers waiting. We've got Phil on the line with a question from Huntsville. Hi, Phil. Thanks for calling. What's your question tonight?
Yes, I have a pre-existing injury question.
Okay.
I fell off a house in 1989 and developed a bulging disc. And I was working here at a local place in town and re-injured that back, and turns out that what was the reason that disc was bulging is there's a hairline fracture behind it.
Okay.
But I aggravated it at a business here in Huntsville. Was sent to the doctor, and that was my diagnosis from the doctor. He gave me 6 days to take about a week, 6 days off, and then go back to work. And so I took my notice to the employer, and 3 days later I was called and told I was laid off.
Okay. All right.
Is there anything I can do?
Pre-existing, and we've gotten he's laid off the job. What do we do with this?
So in a workers' compensation situation, they have to take you as you are.
All right.
Okay, so it wouldn't matter that your back was previously injured back in 1989. If it's an aggravation of that pre-existing condition, then workers' compensation is responsible. And you may have a retaliatory discharge claim as well. As Bobby stated earlier, you're going to have to prove that you were terminated for having filed a workers' compensation claim. So if you were out on leave, that gives you a pretty good argument that they had terminated you for simply being injured on the job and having, tried to pursue a workers' compensation claim. Now, what you may see is they may come up with some other reason, like Bobby had stated. They may say, well, you were late for work 4 times last year, and that's just, We're just now figuring it out and catching up on HR, and we've got to let you go. Well, then the burden shifts to you to show that that's a purely pretextual reason that they've terminated you for. And, you know, so, yeah, you'd be entitled to workers' compensation benefits in that situation, assuming this is a different company than where you were previously injured and that your workers' compensation benefits weren't still open from that prior injury. If you had medical for life as it related to that particular injury, they may have an argument that it's the other compensation carrier that owes you treatment for that.
Okay.
But if it is an aggravation of that pre-existing condition, then you'd have a new workers' compensation claim.
Phil, are you still with us? Were other
Yes.
people laid off as well, or was it just you?
To my knowledge, just me.
Okay.
Yeah,
All
so
right.
there may be something there. You know, I would follow up with an attorney or with us, and you know, let's discuss it and go into some detail and see what we can do to help you out.
Okay. They're telling us take a break. We're going to take a break. Be right back answering more of your questions about workers' comp. Like, how do you get those records? How do you prove your case? We're going to talk about what could Phil or somebody like Phil do to try and prove that case. Stay with us. Be right back.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight we're taking your calls and questions about workers' compensation, being hurt on the job, and the right steps to take to be sure that you are covered by the insurance and things your boss can do and cannot do related to that. We've got William Maservi and Bobby Marsh from Timberlake, League & Brooks. They do these personal injury cases, including workers' comp cases. And we've got callers waiting. We've got Lydia on the line with a question from Pisgah. Hi, Lydia. Thanks for calling. What's your question tonight?
I was calling. I had a workman's comp case several years ago, and at the same time, my attorney also was working on filing for Social Security, you know, at the same time.
Disability kind of claim? Yeah.
Yes, yeah, like disability.
Yeah.
And so my court case came up for the Social Security before I settled the workman's comp case, and so my attorney let the judge know, you know, she's got this court case and that will be coming up for her workman's comp. So I settled, you know, the Social Security, and I settled the workman's comp, and I thought, oh, you know, I didn't think no more of it. And probably about 6 or 7 years later, I get a phone call, and it was from Social Security Department, and they said that I owed them like so many $1,000s, and I'm like, why? Because I thought I probably might owe taxes on workman's comp, but my lawyer said, no, you don't even owe taxes on that. But they said that they didn't know about that case, and I said, but, you know, I said, my attorney even told the judge that I had that case, you know.
Okay.
And I didn't understand any of it, and I don't know what to do about that.
And they want a few $1,000s back from you.
I'm going to guess what happened.
They wanted a few. They first said they just wanted a few thousand, and then when I told them, you know, how much I got from workman's comp, they said, well, we want all of it.
Okay.
Yeah. So I haven't seen any of your documents, but I will tell you there's a piece of the law that, and it's not uncommon if someone suffers a catastrophic injury at work that disables them, they're going to be entitled to Social Security disability on top of workers' compensation. Now, what you get from workers' compensation and what you get from Social Security disability, those two incomes cannot, by law, exceed more than 80% of what you were earning prior to becoming disabled.
Okay.
Okay, and the rationale there is that it would encourage people to become disabled if they could earn what they were earning at the time, right? But the reality is, for anyone who's been in this situation, is you're not living large on 80% of what you were barely paying your bills on.
Yeah.
And so you're entitled to Social Security disability, you're entitled to workers' compensation. But between those two incomes, it cannot be more than 80% of what you're making. And if it is, then Social Security is entitled to an offset. Okay? So if you were making $100 and you get injured, you can't make more than $80 between your Social Security, disability, and your workers' comp. Well, if you're entitled to $100 from Social Security, but you're getting $60 from workers' comp, then Social Security disability is going to get an offset so that you don't exceed that 80%. And so in that scenario, they'd only have to pay you $20 instead of the $100 you'd otherwise be entitled to.
Gotcha.
And so it does get a little tedious to sort through those details, and that's the lawyer's job, is to make sure that they do that right. Additionally, in your closing documents, because it's a workers' comp case, the state of Alabama has to approve everything that's done. So you're either going to have a benefit review conference or what we call a walkthrough hearing with the judge, and they're going to approve your workers' compensation settlement. And in the closing documents, you can spread out your Workers' Compensation Act over, or your, you can spread out your settlement from workers' comp over your lifetime.
Okay.
And so that payment for workers' comp can be spread out over the weeks left in your life expectancy. So instead of you getting $100,000 in 1 year, which gives Social Security an offset for the entire year, then it's going to be $15 a week over the course of your lifetime.
Okay.
And so if that's not done properly, then you can run into issues.
And it could be big dollars, right? If they're coming back 6 years afterward asking for a bunch of money back, that could be alarming. Okay.
Absolutely.
Okay. Good luck with it, Lydia. We've got Jeff on the line with a question from Owens Crossroads. Hi, Jeff. Thanks for calling. What's your question tonight?
Thanks for taking my question.
Sure.
Hey, so in a manufacturing environment, which this is a reality, somebody has an accident, flips over a forklift,
Okay.
and the standard protocol, when that happens, they have to be drug tested.
Okay.
They fail the drug test.
All right.
Are they eligible for workman's comp?
All right.
Possibly. Possibly.
Even with a failed drug test?
Sure. So as I said earlier, it is a defense to workers' compensation if you violated a safety rule. And so if you're in a drug-free work environment, you can certainly be terminated for failing a drug test.
Okay.
But what happens in workers' compensation, if you're intoxicated, whether that be on drugs or alcohol or whatever, the burden then shifts to the employer to prove that your intoxication resulted in your injury. Right?
Okay.
And so if it's a forklift driver and he crashes his forklift into some shelving while intoxicated, the employer's going to have a pretty good argument that the intoxication resulted in that happening.
Okay.
Now, if he's intoxicated and just sitting in the break room and someone's walking past him carrying some shelves and one falls off and hits him on the head,
that's not because he's intoxicated.
It has nothing to do with him being intoxicated.
Okay.
So the employer would have to prove that the intoxication led to the injury. And, and if so, then yeah, he's out. He can't get workers' comp. But if they can't, then he's entitled to it.
Let's give an email question. We got an email question in from Kelly. Kelly wrote, my brother was seriously hurt at work because of safety issues which were ignored by the company. He'll get workers' comp, but does that mean he has no other legal recourse against his employer? Okay. Can you sue your employer in addition to workers' comp? I thought the whole idea was to not be doing that.
You can. So there are a few certain exceptions to the act where, for instance, if this injury arose because they removed a safety guard that was supposed to remain on the instrument or on whatever he was doing, that could give rise to an additional claim. Something you always want to look for when you have a workers' compensation claim is to see if you can also have a third-party claim that would be brought outside of the Workers' Compensation Act, but it would give you regular tort recoveries. So, for instance, if you're driving for your job and you're injured in a car wreck, you may have a workers' compensation claim, but you also may have a third-party claim against the driver who hit you. So it really just comes down to the facts of the injury and what happened on the job. But yes, may have additional avenues of recovery there.
Now,
yes.
Which one of those is going to be more valuable as far as what you can recover, the workers' comp or the...
So typically speaking, your third-party case is going to be more valuable because you're entitled to pain and suffering and mental anguish.
Okay.
And workers' compensation, there is no pain and suffering or mental anguish. And Bobby is exactly right. You know, workers' comp has what's called the sole and exclusivity clause, which means if you're injured on the job, your sole and exclusive remedy is workers' comp. And he gave you some of those exceptions, right? Now, there is some interplay between a third-party claim and workers' comp. And third party just, you know, meaning, like Bobby said, an auto accident or something else. Someone ran the red light and hit you. Well, workers' comp technically has a right of reimbursement legally through the codified law down in Montgomery to be reimbursed anything they paid out on your behalf in the workers' compensation claim. And so they will stand there with their hand out just like Blue Cross Blue Shield would or United Healthcare or any other subrogee in an auto accident to be reimbursed for what they had paid out on your behalf. So they do relate back to each other.
Okay. It's kind of like you've got a windfall there, right? And they don't want you double dipping, essentially.
Yeah, and I think, you know, that there's some legislative reasoning in the law, and I think it has to do with, you know, exactly that.
Okay. We got this email question in from Paul. Paul said, under workers' comp, if I want to see another doctor, because I don't like the one they sent me to, will they still pay for that? I don't trust their doctor. Okay? What are your rights there?
So one thing we haven't talked about is that in workers' comp, you don't get to choose the physician. You have an authorized treating physician assigned to you. Now, if you're not happy with that physician, there is something you can do.
Yeah, so you can actually choose. You have one opportunity to choose a different doctor in that particular specialty, and you have to go before what's known as the panel. We call it the panel of 4. And essentially, if you don't like the provider that was assigned to you, you can go and look at 3 or 4 other providers that have also been selected by workers' comp or their insurance, and then you can choose from that panel. So it gives you an opportunity to look. However, you're still ultimately dealing with providers that workers' comp has selected.
Okay.
Yeah.
You trust those doctors?
You know, there are a lot of good doctors that do workers' comp work, and I think it's like any other profession. There are good ones, there are bad ones, and you know, but certainly there are some good workers' comp doctors out there, and they're not doing just workers' comp. They're taking regular patients, and then they take some percentage of workers' comp patients. But there are some problems with the law, but with the doctors, you know, I think a lot of them do the best they can.
Let's take a break. We'll be right back answering more of your questions about workers' comp. Stay with us. If you didn't get your questions answered tonight, here's how to reach William Meservey and Bobby Marsh with Timberlake, League, and Brooks. They are in Huntsville. All kinds of personal injury cases, from car accidents to nursing home negligence. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon Doviet is our resident family law attorney here in Huntsville. 256-539-7337. That's www.sharonfamilylaw.com, and that's divorce, child custody, adoption. It's family law. Call Sharon.
All that fun stuff. Thanks for all your calls and questions. We'll see you next week.